Hi, my name is Akiva Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate and inform the public, so please subscribe to our channel. When we talk about custody issues, let's not forget that ultimately the court has to determine what's in the best interest of the child. And in order to do that, the statute sets forth a dozen or so factors that the court should consider in arriving at that analysis. So we're talking about the best interest of the child. So oftentimes clients will say, well, hang on a minute. Best interest of the child? Aren't you going to ask the child? Well, it's a legitimate inquiry. I mean, after all, we keep talking the child. Shouldn't we speak to the kid and ask him or her, where do you want to live? With whom do you want to live? I mean, it's a very legitimate question. Here's the answer. The court can take into account the expressed interest of a minor child who is of appropriate age to give that expression of interest. What does that mean? Generally, if the child's maybe 12 or older, the court might consider that as one of the factors. If you got a 5-year-old, the court's not likely to even talk to him or her because that kid, frankly, doesn't know what's in his best interest and will go wherever the toy is the shiniest, okay? Whoever has more candy will be, their heart's desire. That is not a basis for determining custody. But if a child is of suitable age and discretion, at that point in time, the court will take into account the express interest of the child. And here's how they do it. They don't put the child on the stand in an open court, ask the child, who do you want to live with? That would be insulting to both parents and very potentially psychologically injurious to the child. But what they will do is, in most cases, they will take the child into the judge's chambers, sit the child down, and the judge and the child will have a confidential discussion. And the court will take it into account. And the court, in its order, might very well say, I have had a discussion with the child about where he or she wants to live, and I have taken that discussion into account. In other words, the court will make every effort to not disclose if that child expressed a preference, because for obvious reasons. We don't want people to feel bad about it. At the same time, we don't want the child to feel, I can't say anything because I don't want to hurt my mom. I don't want to hurt my dad. So in this method, we try to avoid that. But there's no question that in a certain scenario, we do take into account the preference of the child. But remember one thing. There's a dozen factors of which a child's preference is one. There's 11 other things they take into account. So even if the child says, I definitely, positively want to live with mom for all these cogent reasons, and I'm of suitable age and discretion to express that opinion, at the end of the day, the court can still say no because the 11 other factors favor the other way. So all of these things are taken into account when determining that. So do children have to say? Yes, but the say is limited by the fact that the court does have other responsibilities to make a deeper dive into the analysis of what's in the child's best interest. If you have any questions about that, reach out and we'll be glad to help you out.